Good morning. You're Preston Fontanet, and Mr. Fontanet's case is set for trial to begin with jury selection next Monday. What is the announcement?
Judge, this, up to this point, it's been uncalled for pen time. This morning, it's Mr. Nichols' file. It's at 10 over 10. I've discussed it with him. I don't know what the court's policy is to they withdraw the plea if you reject that.
Today's the day. So, well, you don't get time. So here's the thing, Mr. Fontanet. If you want to take that plea agreement because your case is set for trial next week, today's the day that I number the cases, and I do not accept plea agreements after today. You've had time this morning to visit with Mr. LeBlanc about that new offer. Your case has obviously been going on for some time, so you know what the case is all about. I will hold it if y'all want to visit for a few more minutes, but I'm not resetting the case. If you don't take that deal today, which is fine if you don't want it, then your case will get numbered for trial next week, and there won't be an agreement after today. So I'll hold it for a few more minutes. Y'all visit, and then let me know quickly what you want to do, okay? All right, will your client waive the formal reading of the indictment? Mr. Fontanet, and are we going on count one only?
Yes, Judge.
Mr. Fontanet, the state has elected to proceed on count one only. It alleges you committed the third-degree felony offense of unlawful possession of a firearm by felon, and that's from September 29th of 2022. And how do you plead to that charge?
No contact?
Nope, it's either guilty or not guilty. Did you do it or not do it?
I didn't do it.
You didn't do it? Then we'll go to trial next week.
Oh, we gotta go with it. Well,
So-
I'm sorry,
Let me ask you something, Mr. Fontanet. If I test you today, you're going to have something in your system.
no, ma'am.
Let me double check that. Have a seat, and then we'll talk about your case. Have a seat in the jury box.
I guess I'll step down.
Thank you. Take just. When did you use cocaine?
I don't even use cocaine at all. Like, I really don't. I don't do no type of drugs.
Okay, well, you tested positive for cocaine.
I don't use it. Like, literally, I don't.
Oh, you did something. So here's your option. If you want me to go forward with this plea today, number one, it's guilty or not guilty. Either you did it or you didn't do it. You will go into custody for, either way you're going into custody today, okay? You violated the conditions of your bond. If you don't want to go to trial next week and you want to go forward with this plea, what I'll do is allow you to enter your plea. I'll reset your case for sentencing. I will have an evaluation done, pre-sentence report done, and then I'll determine at that next court date whether or not I'm going to accept the plea agreement. So your choice is trial next week if you want to go to trial and plead not guilty, or for me to go forward with this today and take the plea.
Yeah, I was gonna go with what my lawyer recommended me. I was gonna go with the
So, but here's the thing. It's up to you whether or not, if you didn't do what they're saying you did, then you go to trial. If you did, then you can enter your plea of guilty. But you don't just go along with something. Mr. Blanc, I'm sure, has not told you to plead guilty if you're not guilty. So today, if you want to go forward, it's going to mean entering a plea of guilty and answering some questions that I have of you. Do you understand?
yes, ma'am.
Okay. So is that what you want to do?
That's fine.
Then let's start over. Friend, cause number 23 DCCR 2079. In count one only, you are charged with a third-degree felony offense of unlawful possession of a firearm by a felon. And that is from September 29th of 2022. And how do you plead to that charge? Guilty or not guilty? Are you pleading guilty freely and voluntarily? Answer out loud. And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. LeBlanc?
I believe so.
The papers on the tablet?
Yes.
And do you understand what you signed with him?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I go along with this agreement that you made, you can't change your mind later. Do you understand?
Yes, ma'am.
And it looks like the agreement that you've made is for a 10-year term in prison, but that would be probated and suspended. You'd be placed on probation for 10 years. You would be ordered to pay a $500 fine and follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
There's no objection, Judge.
It's admitted. Is there any evidence that Mr. Fontenette's not competent?
None that I'm aware of, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing, and we'll get the probation department to do a pre-sentence report. I am going to find, based on the nature of your criminal history and your plea in this case, that at this time it is in the best interest of you and everyone else that there not be a bond pending PSI. So you will remain in jail until the PSI. If everything goes well, maybe there's some issues that we need to be have addressed. They'll find that out, and then we can go forward at that point. Okay? You can go back with the bailiff. Good morning. You're Charles Newman.
Yes, ma'am.
And this is 25 DCCR 0545. Mr. Newman was previously in court, entered a plea of guilty to the second-degree felony offense of aggravated assault with a deadly weapon. Has everyone had an opportunity to review the pre-sentence report?
Yes, sir. We have, Your Honor.
Are there any additions or corrections?
Not with this.
The only addition, Judge, is after speaking with the complaining witness, we would request $1,653.75 in restitution.
We are not opposed to that.
1,653.
And 75 cents.
75. Mr. Newman, if I test you this morning, you going to have anything in your system? Let's double check that first. Have a seat in the jury box. Okay. Anyway, we're back on the record. Excuse me, cause number 25, DCCR 0545, and Mr. Newman's here for sentencing. Mr. Newman tested positive for THC, which obviously gives me some concern.
Which, just to briefly address that, he took a drug test just the other Thursday.
Yes, ma'am.
That was for work.
No, that was just to make sure, like, I was doing good and everything. I passed. That's why.
Just to make sure you had everything out of your system
Right,
before you
yes,
came to court?
Right. I just wanted to make sure that I was doing, like.
He had surgery a month ago.
And then I had-
taken
Stop
narcotics.
talking over your attorney. Let him talk.
He had surgery a month ago. He took narcotics as part of that. He's a prescription for that. But he took a drug test just to see if anything was going to show up. Nothing showed up.
Well, THC isn't have anything to do with
That is
a
correct.
surgery.
That is correct.
He's admitted that he uses marijuana. That's
right.
why I had him tested today. So at some point, you used marijuana, and you clearly were making sure it wasn't. If you had a prescription for narcotics, that's not what you were worried about. You were worried about testing negative or positive for marijuana because you admitted to the probation department that you use. And so stop. Take responsibility.
Yes, ma'am.
You shot at a car going down the interstate because they cut you off.
Yes, ma'am.
You barely missed a person in a car because you got pissed that they cut you off. And you're going to sit here and argue to me about using marijuana? I mean, this is crazy. What you did is crazy. The deal you're getting is amazing. And I would think you would come in here absolutely clean, not hoping you're clean and testing positive the week before because you might have used something that might not be out of your system, which is where we are today. All right, anything else before I sentence Mr. Newman?
Judge, I just point out a couple of things that are in the PSI. This is a severe situation, but it's certainly out of character. Mr. Newman has never really been in trouble of any kind before, so this is definitely certainly a one-off. He's always remained employed, had good employment. He did lose his job as part of this case, but he's had surgeries recently and he has work lined up, so he is intending on continuing to maintain the normal life that he's always held, other than this particular incident. Obviously, if marijuana use is a concern, if he can't stop using marijuana, they're going to figure it out at probation, whether that's drug testing or a patch or whatever the court decides is necessary for that. But it's not using, worse drugs that would be even more concerning considering this case. So we're just asking the court to follow the deal and impose whatever drug conditions the court deems are necessary.
Mr. Smith, anything else?
No, Judge.
All right, so Mr. Newman, what I'm going to do, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 10 years. You're ordered to pay a $1,000 fine. You're ordered to pay restitution in the amount of $1,653.75. You will be ordered to enter and successfully complete the JCDI program, which is an intensive outpatient treatment program. Obviously, if you're using this close to court, you're going to get some treatment to make sure you're not. You will be required to wear a drug patch until further order of the court. I am also going to order that you serve 15 days up front in the Jefferson County Jail. And so you'll talk to probation today. You will go into custody. And this is just too serious of a case for me not to make sure you understand some consequences of your actions. To be coming in here for shooting at someone in a car, testing positive, is just, it's not okay. And you need to understand that. So this is still an amazing opportunity. You don't have a felony conviction on your record. So if you successfully complete the probation, and Mr. Galmore's right, this is apparently seems to be very out of character, but it's so serious that it's just something's going on, and we're going to get that figured out. And so if you do everything you're supposed to and you're successful on this probation, the case gets dismissed at the end. You will never be a convicted felon. But the other side of that is if you violate any condition of probation, you will be brought back into court. You could be found guilty of the offense, and you could go to prison for up to 20 years, anywhere between 2 and 20 years for this offense. One of the things that makes me a little more comfortable, I guess, you're very lucky that the victim of this offense, number one, didn't get hurt, and number two, is in agreement with you getting this help and being on probation and making sure you follow through. So you should be very appreciative of that. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You can go with the bailiff. Probation will talk to you in just a few minutes before they take you back. Good luck to you, sir.
Did we confirm that Harold's?
Good morning, sir. You are Isaac Mitchell? And Mr. Gertz, will your client waive the formal reading of the indictment?
He will, Judge.
Give me just a second. Mr. Mitchell, in cause number 25 DCCR 0587, the state has elected to proceed on the lesser included offense of a Class A misdemeanor, assault family violence, from April 17th of 2025. And how do you plead to that charge? Speak up. Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they've charged you with?
Yes, Your Honor.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
And it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, Your Honor.
In addition, there would be a dismissal in it looks like you have misdemeanor court as well as the felony in cause number, 25 DCCR 0588. Is that your understanding?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, Your Honor.
State tenders number 1.
Judge, we have no objection.
It's admitted. Is there any evidence that Mr. Mitchell is not competent?
None at all, Judge.
And the agreement is to get a pre-sentence report, correct?
That's correct, Judge.
I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. And y'all had an agreement for something else?
Yes, Judge. So currently his bond conditions include a GPS device and no contact with the complainant. We have agreed that we will, I don't know if the word is waive or alter those bond conditions to remove those 2 conditions.
Okay, and you
Judge, I
have,
have no objection to that. The record will please reflect that the complainant, Ms. Burleson, in this case, this is a young, newly married couple. First baby is on the way very shortly. She has written, sent certified mail, email, called, all about non-prosecution, and obviously no bass, but I think my intention was to allow this probation so that in both of their best interests, maybe they can get that if they need it.
Okay, so then, Mr. Mitchell, what I'll do is modify your bond conditions to remove the no contact with Hannah and to remove the GPS monitoring device. Obviously, this was a situation that got out of hand that cannot ever happen again. Right now you're still on bond. If you violate any other conditions, if anything else happens, you're going to be right back in jail. Obviously, when you're on the probation, same things get you on a different path. Some treatment, maybe classes, things that will help you become a better husband and father as well, because obviously you don't want a child involved in any type of situation like this.
And I believe he has completed BIP. She has also
good.
completed the options class. The court would consider, especially during the pendency of the PSI, that the order not to have any handguns or firearms of any nature in their home. I think that's what escalated this, what probably was obvious to me.
And I already advised him of that, Judge.
Okay, so if there are any, they need to be removed. You're not to be in possession of, and that doesn't mean just in possession on your person, in your house, car, anything else. You can't live with somebody else that has guns. Just no guns, period. Do you understand? All right, then you need to talk to probation on your way out of the courtroom today. She's sitting at that desk right over there, and then we'll see you back at sentencing.
And there it
Thank
is,
you.
a moment that defines
Okay,
choices,
perfect.
consequences, and the weight of truth. Today, a decision was made, one that cannot be undone, a plea entered, a future altered. In this room, every word, every hesitation, carries the gravity of what comes next. The law is clear, yet human hearts wrestle with guilt, fear, and responsibility. What would you do if faced with the same choice? A courtroom may close, but the questions linger, long after the gavel falls.